next agenda for the day, and it's very hot topic for the day. Before that, let me wish all of you a very happy Gudi Padwa. Let the new year will be a great year for all of us as regard the health, as regard the wealth, as regard the other activities, professional activities. Let it be a very marvelous year for all of you. And I, Unmesh Narvekar, is taking this hot discussion ahead regarding the CAWA bill, which is passed in a couple of days before in the parliament, and its impact analysis. Now the bill has already been passed. Then we need to understand how it's going to impact, what are the pros and cons, what are the points, and what way it is going to affect the entire fraternity. With few opening remarks, I will take on this topic for further discussion. I think Mr. Barve is there, sir. Barve, sir, are you there?
Hello. Hello.
Barve, sir. Ayatna Tumi, are you there?
Yes, I can hear you. Yes.
Yeah. So now the point is that a legacy of 72 plus years of ICAI. 1949 we started a journey as a chartered accountants, and it is been seen a repute of ICAI was such a high that we have heard from the many stalwarts that yes, the finance minister used to come before presenting the finance bill. They have to have discussion with the chartered accountant president, ICA president, about the happenings, about the points in finance bills, and then he's going for the finance bill presentation. This was such a high level prestige things what we enjoyed, the pride we enjoyed, and over a period of time things have been moving in a different way. And especially if you can see more than a decade, last decade was, or maybe more than 1 or 2 years here and there, but we've seen that there is some drastic changes taking place. No doubt change is a constant always, and by the day goes, change is happening in every sector, every field, every economy, every country. We are not far from the change, but in spite of that, the changes that are going to take place after this amendment are having a long impact on the CA profession, whether it is good, whether it is bad, whether it is neutral, or how it's going to, it is a need of R or it is not, or still we can have a self-regulatory mechanism, or we should be an autonomous body, continue to be an autonomous body. N number of thought processes are there in the minds of the chartered accountants. Yes, even council has kept a meeting. The impact analysis will be there on 5th of this month. Then there will be some more discussions. There will be even dharna has also been planned by some of the organization of chartered accountants associations. Few things are happening across the country, but let us understand this from the stalwarts. I think I will invite our stalwarts, this ex-council, central council member, Mr. Shashikant Barve sir, to give his opening remarks on this thing. And then we will take point by point analysis or open discussion from every people who are going to deal with this thing. Mr. Barve sir, are you there? Can you just take up the initial discussion about the bill?
Thank you, Umesh, and thank you, the organizers. What I would do is factually, within say next 15 minutes, I will explain what the bill contains. Now, once we know what the bill contains, then it would be easier for the participants to express their views. Now, the objective of this amendment bill, the bill is the Accountants, Cost and Works Accountants and Company Secretaries Amendment 2021. Now, the objective of the bill has been stated as strengthening the disciplinary mechanism, providing time-bound mechanism for deciding the cases, avoiding the conflict of interest between the disciplinary authorities and the executive authorities, then provide for accountability and transparency by certain measures like provision of audit by certain companies. Then there would be autonomy given to the institute for fixation of fees. Now, these are the basic objectives that have been indicated by bringing the bill. It has already been passed by Lok Sabha and it would be passed soon in the Rajya Sabha. So this will become act very soon. Now we will see what are the changes brought in by this amendment bill. The first change is title of the act itself The title earlier said that the act was for regulation of profession. Now they have said it would be for regulation and development of profession. So there would be a very, very wide coverage for the act, and many things can now be achieved under the term of development. The other change has been made is earlier the president of the institute was the chief executive authority. Now the secretary has been made the chief executive officer and president has been made as the head of the council. There have also been specific amendments whereby the functions of the institute have now been separately described. Probably they will be functions of administrative nature which would be looked after by secretary, and there have been appropriate changes in the function of the council in section 15. There is another provision which has been brought in is earlier the audit was done by the firm appointed by the council. Now it has been specified that the audit would have to be done by a firm which has been registered on the panel maintained by the CAG, Controller and Auditor General of India. So it is not audit by CAG, but it is audit by a firm empaneled by CAG. The another major amendment has been brought in is the council has been given autonomy to decide the fees. Earlier, there were certain thresholds beyond which, if the council wanted to enhance the fees, they would have to approach the central government. Now, council has been given complete autonomy to decide all sorts of fees for members and students, which would be entry for COP, entry in the register of members, or annual COP fees, or annual membership fees, or examination fees, etc. So full autonomy has been given to the institute to decide the fees. Now, there has been an important amendment which has been brought into, which provides that the register of member will include the information about the whether any complaint is pending or whether any penalty has been imposed on the member under the disciplinary proceedings. So the data would be available in the register of members against the name of the concerned member. The another important provision has been brought in is that there would be a coordination committee formed. The coordination committee will include president, vice president, and secretary of all the three institutes, that is chartered accountants, cost accountants, and company secretaries. And at the end of each quarter, there would be a meeting held under the chairmanship of Secretary MCA, Ministry of Corporate Affairs, and all these dignitaries of the three institute. And there would be various functions which have been defined to be undertaken by this coordination committee. The bill was referred to the Parliamentary Standing Committee, and there only ICAI had objected to formation of such formal coordination committee, but the objection has been overruled by the Parliamentary Committee. And there would be a coordination committee under the chairmanship of Secretary MCA. There is one more provision which has been brought in, where now all the practicing firms will have to register themselves under a separate register of firms, which will come under the control of the disciplinary authorities, because there are provisions for penalizing certain firms also in certain situations. Therefore, all the firms would now be required to register separately. The another provision has been brought in, the intention
I think that
Barve sir. Hello.
I guess Barve sir got locked out.
Yeah, logged out. Just a minute.
No, sir got locked out. I can't see sir in participants.
Yeah, his name is not seen in the list. Okay. Till the time he rejoins, we'll take the discussion ahead, and we can take yes. Yeah. So Tulsian sir.
yes, sir.
Yeah.
So, hi,
I'd like to have your comments on this initial discussion. Yes,
welcome,
sir.
welcome all, and thank you, Mehdi, Manojji, for giving me a chance to share my thoughts on this proposed bill, which has been brought by the government, and it amend the CA Act 1949, Cost and Work Accountant Act 1959, and Company Secretaries Act 1980. These three acts, they would like to amend these three acts and our act, a Chartered Accountant Act, which was passed before the our constitution was passed, because our act is Chartered Accountant Act 1949. We are in last 71 years, we are delivering consistently delivering better results, better performance, and we have a tie-up with the all the major accounting body in the world. And our performance, our executive, our students are performing well, and their contribution cannot be denied by anyone. Now, there are few things which we need to discuss over this panel, and this is my thought, and this is not representative of uh, any statutory authority or our CA Institute views. This is all my personal views, and which I am sharing with all of you. So, what the hue and cry by the chartered accountant by this amendment bill? See, the thing is, when the government brings the bill of chartered accountant, cost and work accountant and company secretary amendment bill 2021, there were few provisions which were there, and there are few provisions which were not there. One of the things which were not there in the original bill was IIA, Indian Institute of Accountant, which they bring it in this bill when it gets passed in Lok Sabha. And the government, what they would like to do is basically, I will give you some brief also for chartered accountant, for my friends. What is the chartered accountant disciplinary mechanism specified under the Act, and why, where the differences are, and why the differences are, and what is the solution? I will try to touch upon all these items. One is disciplinary mechanism provided in our Act, Act, which now I was just speaking. Barve sir.
Hello, just can you hear me?
Yes, sir. Now we can hear you.
Just a minute. So there is another provision which has been brought in, and the objective is stated that the council term should be of 4 years, and maximum there should be 2 terms which a member can serve. Now that is the intention which has been specified, but if we go through the actual wording which has been brought in by the bill, it indicates that all the existing members would get now 3 terms. So the intention was that they should get 2 terms of 4 years each. Now what will happen is they would get 3 terms, even though the objective is for 2 terms. And in fact, there is appears to be a lacuna in the wording whereby if a particular member is serving his third term, then he may get one more additional term of 4 years. So there seems to be some problem in this particular provision which has been brought in. So that the objective intention was that every member should only get 2 terms, that is likely to get defeated. There is another provision which has been brought in, is the president is now made responsible for ensuring that the decisions of the council are implemented. So that is an additional responsibility has been passed on the president of the institute. There are certain functions which have been prescribed for council, and there are certain functions under section 15B newly introduced section, whereby functions of the institute have been bifurcated. Now additional functions which have been specifically now given under the functions of council include the conduct investor education awareness programs, or to enter into any memorandum or arrangement with the prior approval of central government with any agency of a foreign country for the purpose of performing the functions under the Act. So these are additional functions which have been now provided. There are major changes in the disciplinary mechanism, and the objective has been specified in the bill itself, that the objective is to strengthen the disciplinary system and to provide a time-bound mechanism to decide the cases. So the first provision which has been brought in is that the appointment or reappointment or removal of the director discipline would have to be with the prior approval of the central government. Similarly, the 2 new positions, that is joint director of discipline, have been stated to be recruited or instituted so that the cases can be handled by the joint directors of discipline. The provision has been made that within 30 days of the receipt of information or the complaint, the director discipline has to decide whether the complaint or information is actionable, or if it is liable to be closed as non-actionable. If it is non-actionable, then it would be referred to the board of discipline to take the final call. It has been now specifically provided that the disciplinary directorate can do suo motu investigation. The provision has been made whereby it is stated that the director discipline shall submit a preliminary examination report if a prima facie case is made out against a member or a firm. Now, the serious matter is that if the director discipline receives a complaint from the government authorities along with the investigation report, then that itself will be treated as a preliminary examination report. So earlier there was provision to form a prima facie opinion whether the member is guilty or not to start the proceedings. But here now it has been provided that if the complaint is from government authorities supported by investigation report, that itself will be treated as a preliminary examination report, and the further proceedings can start. Similarly, earlier there was a provision that the complaint lodged could be withdrawn, but now it has been provided that the complaint once lodged cannot be withdrawn under any circumstances. The other important provisions are, in the case of board of discipline, earlier there were 3 members and 2 were from the council and 1 nominated by the central government. Now it has been provided that the 2 members, the presiding officer and 1 more member, they will be nominated by the central government. So out of 3 members, 2 members would be nominated by the central government out of the panel which will be prepared and presented by the council, for which the specific rules will be formed. So the council would prepare the panel, and out of that panel, central government will nominate persons. But out of 3 members, now 2 would be nominated by the central government. Similarly, in case of disciplinary committee, earlier out of 5 members, 3 members were from the council and 2 members were nominated by the central government. Now it has been provided that the presiding officer and 2 more members, that is 3 members, would be nominated by the central government, but they would be out of the panel which would be prepared by the council based on the rules to be formed by the central government. So out of 5 members, now 3 would be nominated by central government and 2 members would be nominated by the council out of the panel, and the methodology of forming panel would be defined by separate rules. Now, for these particular amendments, ICAI had objected for such amendments, but the parliamentary committee has overruled those objections, and they have indicated that the conflict of interest should be avoided, and there have been similar cases in UK, USA, Australia, Canada, South Africa, that there are independent authorities which are involved in deciding the disciplinary cases. As far as timelines are concerned, it has been prescribed that the Board of Discipline has to conclude its inquiry within 90 days of the receipt of preliminary examination report from the Director Discipline. Now, it has also been provided that for both for the Board of Discipline and for disciplinary committee, while considering the cases placed before them, they will follow such procedure including faceless proceedings and virtual hearings as would be specified in the separate rules to be formed. The disciplinary committee has to conclude the inquiry within 180 days from the receipt of preliminary examination report from the Director Discipline. So the Board of Discipline considers cases of falling in the first schedule, while disciplinary committee considers cases falling in both first and second schedule. The punishments also have been substantially enhanced. In the case of Board of Discipline, they can either reprimand the member, and the amendment is that it would get recorded in the register of members. Similarly, they can remove the name of member from the register up to period of 6 months. Earlier it was 3 months, and they can also impose the fine which may extend up to 2 lakhs. Earlier it was the fine up to 1 lakh of rupees. Similarly, in case of disciplinary committee, they can reprimand the member and importantly record it in the register of members, or they can remove the name of the members from the register of members permanently or for the period as they may find appropriate, or they may impose fine which can extend up to 10 lakhs of rupees. Earlier it was 5 lakhs of rupees. The another important amendment has been brought in, whereby it is mentioned that the power is now given to the disciplinary authorities to proceed against the firms. Earlier, the proceedings could be undertaken only against the individual member. Now it has been said that the proceedings can be taken against the firms also. But if we see the wording of the provisions contained in the bill, one can find that it is extremely difficult to cover many firms for the purpose of punishments. It has been mentioned that only if it is found by the Board of Discipline or by the disciplinary committee that a member who is a partner or owner of a firm has been repeatedly found guilty of misconduct mentioned in the schedules during the last 5 years, then the actions can be taken against the firm. So, even though the provision has been made for taking action against the firms, practically it appears to be very difficult to involve or to initiate proceedings against many such cases, because it's difficult to find the cases where the member who is a partner is repeatedly found guilty during last 5 years. The amendment which we already spoke of, the appointment, reappointment and removal of director discipline and 2 joint directors of discipline has to be subject to prior approval of the central government. Now, there is one more clause which has specifically now brought in the second schedule specifying the misconduct, where it has been stated that the professional misconduct in relation to members of the institute, where the member acts as an auditor of the company in contravention of the provisions of Companies Act 2013. So now a specific provision has been brought in. Now, there have been various penalties which were prescribed under section 24, 24A, 25, 26, where the who is not a fellow member, but if he or a member who is not holding the certificate of practice, but if such a member is representing that he is in practice, or if any other person who is not a chartered accountant, but if he is proclaiming that he is a practicing chartered accountant, in such cases, the penalties have been substantially increased. Now, there is one more amendment which has been brought in, which specifically now empowers the Quality Review Board to forward the cases of non-compliance with various statutory and regulatory requirements by the members noticed by it during the course of its reviews to the disciplinary directorate for examination. So the Quality Review Board earlier dealt with various subjects regarding the quality of the reporting, but now it has been specifically, they have been authorized to forward the cases of non-compliances to the disciplinary authorities for taking action against the members. Now, this would be an important amendment where the members can get seriously affected. Now, there is one more provision which has been brought in, which specifically says under section 22G that no action taken under the provisions of this chapter shall bar a central government department or a state government or any regulatory body to take action against a member or a firm under any other law for the time being in force. So it means specific provision is there now that the other authorities, other regulatory authorities can simultaneously take action against the members. Interestingly, there were 2 items and which have become now a matter of discussion among the fraternity. When the bill was submitted to the parliamentary committee for their opinion, now apart from various other matters which we have seen, they have specifically mentioned 2 items. One item is the name of the cost accountants, cost and works accountants of India. That name should be only cost accountants of India. There were representations from them that the name should be cost and management accountants, but it appears that it has been rejected and the name would suggested is only cost accountants instead of cost and works accountants. Now the another important suggestion or recommendation made by the parliamentary committee is formation of the Indian Institute of Accounting. Now, the actually this subject is not there in the bill itself. It talks about increasing the competition. Now, the bill is given to the parliamentary committee for their suggestions on the items mentioned in the bill. So this subject of increasing competition really did not find any place in that bill. But yes, the parliamentary committee has now come out with a specific recommendation, and they have said that while during the course of examination of the bill and scrutinizing the global practices with regard to the profession of accountants, it has been observed that the qualification and licensing of accountants in advanced countries like US, UK, and Canada is done by multiple bodies, unlike in India, where one institute has statutory monopoly over the whole profession. As such, the scope for improving the quality and competency of the profession remains limited. The committee during their deliberations feel that multiple bodies on the lines of advanced countries is required in order to promote healthy competition, raise the standard and quality of auditing and accounting, and improve the credibility of the financial reporting. The committee desires that the government should consider setting up of institutes of accounting similar to IITs and IIMs for further development of the accounting and finance profession in the country. That is the finding or the recommendation given by the parliamentary committee. They have also described that there is a proposal of establishing a string of Indian Institute of Accountings that will raise the standard of accounting education and offer competition to the Institute of Chartered Accountants of India. And there are various suggestions given how the IIAs will be formed. They will be the statutory bodies under the central law similar to IIT or IIMs. They will be set up in different parts of the country. Their board will have full functional financial and administrative autonomy for its efficient functioning. Then they have also said they will have their academic council and they will start with a 5-year undergraduate program in accounting. Over the time, they will develop postgraduate programs in specialized areas like forensic accounting, business analytics, cyber security, valuation, international tax, etc. They have also said that these institutes will be research driven and they will support research and publication effort by their faculties. They have also said that from the beginning, the IIAs will have international outlook. They will have students from all over the world, including from developing countries. They have also said that they should price their education reasonably and provide financial aid to the needy students. The important part is these institutions will be given a license to practice. The institutions can give licenses to the students who have passed their examination to practice similar like chartered accountants. The license holders will be called certified public accountants and they will be required to register themselves with the central licensing authority, maybe like NAFRA, which will handle their disciplinary matters also. Now, the examples have been given about USA, UK, Canada, where such multiple agencies have been operating. Now, these are the important provisions which have been brought in by the Amendment Bill 2021. Unmesh ji, Manoj ji, I think I have covered all the major proposals which have been brought in the bill.
Thank you, sir. Thank you, Barve sir. Excellent detailed analysis of the subject about the amendment bills. Now, in this background of these highlighted points of this bill, first question comes, is it a dilution of ICAI? That is the first thing. And that is where the thought process goes in the mind. Is the ICA getting diluted? The authority is getting diluted, the autonomy getting diluted? Yes, sir. What is your views on this? Then we go to the Tulsian sir and Vora sir one by one. Sir, your views on this, whether it is a dilution of the ICA itself?
It's see, it's difficult to say it is dilution because there has to be healthy competition. It's not only they have given the international scenario, what is happening in different countries, but also if there is a competition between different institutes, then overall there should be the improvement in the quality of services. And I think there should be healthy competition instead of creating a monopoly and to avoid the conflict of interest. Now look what is happening here. And if you have heard the speech or the reply given by the finance minister in the Lok Sabha, she has clearly stated few things and they are very important. When the issues were raised like the government is not funding these institutions like ICAI, she had said, look, what is meant by their money? The parliament has formed an act and given power to the institute to undertake all the functions and the charging of fees. So whatever income they have generated is because of the parliament giving them their authority. So look, the perception of the authorities is a different perception than what one may see or one may like to hear. But that is the perception given by the finance minister. And she has also asked, what is wrong if there are multiple institutions who would be giving training, who would be giving the licenses, and who would control or regulate or undertake the disciplinary functions? Because here she had said specifically that one institute has been given powers to train the people, then to regulate them also, and to discipline them also. So there seems to be all the functions getting concentrated in the hands of one body. And looking to the international scenario, it may be better from the point of view of profession that there are multiple agencies in the different areas like education, regulation, and disciplinary sections.
Thank you, sir. Tulsian sir, a direct question to you. In this background, do you feel that in 72 years, SRO, self-regulatory organizations, have failed to manage themselves, to control themselves, to regulate themselves? Is it a mechanism which has been designed in 1949 to do everything by ICAI under the Act of Parliament? Are we failed to maintain that levels? Tulsian sir, your views, please.
Yeah, say, Praveenji, we have not failed, or ICI have not failed. Rather, we can say we have done the extraordinary work to popularize this chartered accountant profession. And we are the only one profession with proud, we can say that our chartered accountant are competent enough to take any responsibility throughout the world. We are the best in the industry, as well as we have provided the skills which is required to run the profession as well as the industry. Our chartered accountants are now at various places, various prestigious places also. We are not failed, but we have somehow, I feel, this is my personal view, that our dialogue with government have failed due to some of the members, council members, who have not interacted government, and they are not able to convey the message that what chartered accountant is all about. You cannot
do you feel, sorry to interrupt, do you feel it is not the failure of the profession, but it is the failure of the council to communicate our standards?
We
Please.
we can say that it is not a failure of chartered accountant. It's a failure of a little bit, uh, uh, what we can say is a council who should press the matters before the government in the way what it should be. It is not done. Why? I will tell you one example where we can clearly see that our chartered uh, accountant comment on us, a chartered accountant, is done by Gopal Shetty, MP of the House, and he himself is not even a graduate, and he's saying that our chartered accountant profession is doing nothing, which is totally wrong, and we should oppose. We should oppose all the chartered accountants today also in Jantar Mantar in Delhi. Chartered accountants are protesting, but protest is for what? Protest is for our dignity. See, we have performed very well. The chartered accountant in numbers of 3.5 lakhs in numbers, and what government got in GST or income tax or any act when it comes, we are the one who help the government to uh, get the taxes on time. We do all the compliances, we run the industry, we do everything. The failure is that we are unable to convey the message what we have done for the society. We are a net partner in national building, but somehow this message has not been gone very well with the government. This is the
Sir,
failure on this part.
just when it was step ahead, are we not united enough? The profession is not united enough to withstand with this, because today if the dignity is to be maintained, the communication is to be made to the government, then why the dharna is by only chartered accountants, not by any of the council? Why the council has not come out with a discussion? Why they have not talked to the government that this is not the case? Because in the Lok Sabha, we have seen the MPs have done the Vastraharan. Actually, उन्हें वस्त्रहरण कर दिया हम लोगों का कि ये हो रहा है, ये हो रहा है. We are the culprits. So and so, blah blah blah. I don't. People who are not having the qualification, they are MPs, but they don't have the qualification what the CA is serving. I've been talking in such a manner that we are shameless people. Rather, we are not done anything for the country. So, do you feel that we are not united enough as the bar council members? If you see, or any other profession, medical profession,
Yes.
once they say yes, no, pen down, pen down. Once they say no work, no work. Are we not united enough? Please.
Umeshji, my point is very clear. We have not kept the government in proper loop. In 2013, when the first time NAFRA came into the provision of the Companies Act, we are unable to prove our metal before the government that NAFRA is not required because of the disciplinary committee. Again, when it came, we welcome it. We again welcome it, whatever changes are coming up, because the government is a progressive government, but at the same time, we are unable to pass on our message to the government very well. I will tell you one thing, the MPs who are telling that this chartered accountant, what is the chartered accountant is all about. I will just give you a brief. A chartered accountant's son cannot be say that he will become a chartered accountant, because he have to, and we are not dividing anyone. Everyone who has passed the chartered accountant, they know, because they have their honest hard work, they have passed the chartered accountant exam, not because of their money power or post power or anything. It's a course which we have earned, not given by anyone else. So the commenting on us is not their prerogative, and we should ask apologies from those MPs. Now, the point which you have rightly posted, that we are not united. Yes, we are not united enough, because the date on 28 or 27, 28, when the act was passed in Lok Sabha, we are unable to show our strength like any other profession, like lawyers and others. See, we are not united enough for our own betterment. The chartered accountant fraternity are divided on this point, because they are not knowing the fact. Our council members are unable to pass on the message, a clear message to all the chartered accountants. These are 350,000 chartered accountants only. Why we are undivided? Because this is a last nail in the coffin, or we can say that we are not united. If we are not get united, our profession is going to competition by IIA also in the future, which was not part in the original bill which was bring. And even the parliamentary, before the parliamentary commission, parliamentary committee, our representation was that, okay, whatever you have done, we can accept most of the things, because what government wants is their own people to chairing on the disciplinary committee. Yes, I can
Sir,
understand.
here I will just stop you and I will ask the Sanjeev Vora sir. Sanjeev Vora sir, are you there, sir? Please. Sanjeev Vora sir. Vora sir, are you there? Okay. Sir, is it a backdoor entry? Tulsian sir, point I
Yes.
am taking to you again. Is it a backdoor
Yes,
entry
I
by
also
the
think
government
the
on
government
to
is
regulate the
doing a
profession?
backdoor entry. It's a backdoor entry of government in the profession, because in the all of the three institutes which they are merging, they are more concerned on the chartered accountant, because we are in number, we are 350,000 around, and whereas the both the other institute is not more than 50,000, 60,000 people. So they want to a backdoor entry, even though they are a member. Still, right now they are a member. Now, what they want, instead of 3 council member and 2 government nominee member, they want 3 nominee member from the government and 2 from the council. No issue, we can give, but whether they are capable enough to decide on the work done by the chartered accountant, or whether they will go with the market perceptions or the complaint only. Because whenever any failure, like why these amendments are coming, they are saying satyam or other frauds which happened in the past. Now, whether we are able to fix the responsibility of chartered accountant by any other person, like we have seen in the Lok Sabha, a person who is not well qualified is giving opinion on the qualified person. If he have enough power, he can pass the CA exam, which even president or the chairman cannot tell that their son or their family member will pass the exam because they have become a chartered accountant. So,
sir, one point ahead. See, there was an opening remark in few days before by the president ICAI. Audit is a serious issue. If you cannot do, if you are not enough to do, you have to be away from the profession. Is it a mentality of accepting the change, of accepting the IIM, or is it something like that? Sir, Barve sir, can you just put on your views on this?
Hello. Hello, Unmesh. Hello.
yes, sir, Sanjeev ji.
Good morning, Rakesh ji. Good morning, Unmesh ji. Good morning, all the participants. It's a very good discussion going on.
Good
And
afternoon.
first of all, happy Gudi Padwa to all the participants. And what I have to say, that we are not against this competition being brought in by IIA and all. But what we have to say is that all these years, 74 years or whatever, it has been managed very well. So we should not be accepting this also at the same time. Okay, we are not against competition. We are here to beat any competition or meet any competition.
My
Sir,
point is
it
I
like that? Is
also
there
agree with
resistance
your
to change?
our syllabus or our exam pattern, we don't have to worry about it. Let any IIM or IIT people will compete with us. See, passing the IIM or IIT is not a big work for a chartered accountant, but passing a chartered accountant, even lot
Yes,
of
yes, that is what.
or
Yes,
IIM,
our own exams are really tough. And
yes.
as everyone knows it, whoever has gone through these exams. So what I would suggest is that our own chartered accountants should unite and we should oppose this.
Yeah,
Yes.
you mean getting into IIT and IIM is very easy?
Sorry.
So rather the point is getting an exam passed out is one thing, but implementing those standards in the profession,
Yes,
are
yes.
we failed to that level?
Not at all. Not at all.
Not at
See,
all.
my
Why the
question was
government thought process is that?
getting into
Why the
my
government
question
thought
was
process is that?
my question was getting into IITs and IIM was very easy. You mean passing a JEE is very easy, or passing a CAT is a very easy?
No,
Not at
even
all.
though, even if it is a not a passing is easy, you can go by paid seat. So till now in CA Institute, there is no paid seat. You cannot pass, if you are not able to pass, you cannot buy a chartered accountant degree, a profession. You cannot
See,
do it.
if CAs are so much, then why the so-called highly paid PwC when the why the Satyam went on a scam?
So
Such a
now,
big
now
PwC CA.
the question is that why we are unable PwC scam or Satyam scam have happened, because the appointment which is done by the management. How can you feel that a person who is appointing you,
If CAs are so much regulated and so much conscious, then they should have said, Mr. Raju say ki, I cannot sign this. It has been the audit. It has been signed by PwC, such a big audit firm. We can't. Just sorry to say that you can't blame on the completely on the management of Satyam.
so we are not saying completely,
Ganesh,
we are pointing
Ganesh,
on management only. The chartered accountant itself is guilty, and they are found guilty also. Now the problem.
Exactly. Thank you for accepting even some of the chartered accounts are.
Ganeshji,
No.
let me tell you, the most difficult frauds to find out are management frauds. Where the management itself is committing frauds, how can you blame the chartered accountants?
And now, how much time you are giving to for the audit? How much time? Like government is saying, even PSU banks, where there is a lot of NPA issue. How can you blame a chartered accountant not to point it out?
It's a
Because-
management which is committing, and chartered
Then
accountants are blamed.
you
A
should
chartered
go back to.
accountant who will work for 24 hours for
एग्जाम नहीं कर
365 days. He cannot
आपको
bring
आपको
out.
आपको लंबा फीस भी लेना है और काम भी टाइम पे नहीं कर टाइम शॉर्ट है, then you should go back and say
So that's
to the
why
management.
I also agree with the government step which they are saying that there should be an increase in disciplinary mechanism. Yes, we agree. There should be increase in disciplinary mechanism, like what they are saying is a form. Right now in our CA profession, the chartered accountant is found guilty, not the firm. So going forward, the government is bringing this changes that where the firms will also get penalized. So that is a welcome move. We can welcome. We cannot 100% against the government.
But sir, my point is, see, we are a postmortem. We are doing postmortem. We are not doing pre-audits. The management is the first thing. They are taking the call. They are taking the decision. They are making the implementation. What comes in our hand as a chartered accountant, as an auditor, is
Umesh ji,
things happened.
Umesh
See,
ji,
the point, my point is just to be highlighting on this issue. Why the first whistleblower we can do at the most, we can highlight these issues in our report. But what happened already, the money has gone. The things have already happened. So
Umesh
whether
ji,
the failure is of a chartered accountant or a failure of a management internal control.
Internal
Umesh ji,
control, I would say, Unmeshji, it's an internal audit which should be blamed. Statutory auditor comes in the end, and where everything has already happened. Internal audit is not
I
pointing
agree.
out the things. And
I
so,
agree, Sanjeev ji. But the thing is, if you see the government intention, they are not saying only chartered accountant.
Sir,
Companies will take-
I have a question. How many people have worked in a company? Is there anybody who has worked in the company who has worked there before as the auditors?
I have worked in a industry, I worked in a bank, and now I am in practice. So I can put, and I am also having government views why they are bringing and why they are not bringing the changes. See the things which we are saying. We are looking at the chartered accountant. Why you are forgetting about the cost accountant as well as company secretary? So all those are 2 or 3 institutes coming together. It cannot be done if we have all 3 institutes have worked fairly. This was the common intention. Yes, we should agree on some point, but we cannot agree on few points which government is talking about this Amendment Act.
Correct, correct.
Unmesh
Even
ji,
NASA was not required at all.
Yes, Barve sir.
Unmesh ji, see,
Yeah.
there are 2-3 statements
Yeah, please.
which I would like to make. One, see, apart from factual situation, what matters is what is the perception of the other person. Now, what has been the perception when NFRA was formed? What actions we had taken? Similarly, on 1st July 17, when the Prime Minister spoke about certain things about the profession, what sort of actions we had taken? Now, even the Finance Minister spoke in the Lok Sabha now that the self-regulation has not worked. That is a categorical statement which has been made.
Yes.
So the perceptions matter. Now, the auditor's job and the job of investigation or forensic accounting are different. That is fine. But then how do we convey that thing to the others? What is their perception? Now, you
Sir,
mentioned
here is the
about,
point. Sir,
you
just a
mentioned
minute. Here is the
about,
point. Here is the point. Whether this failure is of a chartered accountant or whether a failure of a council. See, the perception of a person or regulator or the government is created not by any individual. It is the council who is the leaders. Elected leaders are the dialogue between the profession as such and the government or so many other people, stakeholders. So whether the projection of a profession through the elected members is failed to that level, or they work for their interest or they work for the profession. What is the exact point? Can you just highlight, please?
see, last 70 years, if you see how the image or how the perceptions have been changing, did you find the perception which is noticed today? Did you find that perception 20 years ago? And what has happened during last 20 years, whereby the things have started happening in such a way that the perception, we call it perception, but the other person talks it about a factual situation. So the how to correct those perceptions is a very, very important matter. And also one needs to introspect how far is it right to have all the functions in one basket. You train the people also, you form the regulations for operating also, and then you try to discipline them also. There is something called as basic conflict of interest. Now, how far is it right to have all the functions in one basket is a matter which has to be internally studied by us. There should be introspection as to really in democratic elections whether it is possible to have to give such control or all the functions in the hands of one authority. Now, one has to introspect by looking to what has happened during last 10 years or 20 years. Then one would realize that to what extent it is perception, to what extent it is factual thing, and what are the things which need be done to avoid such a situation.
So 2017 was a whistleblower by the Prime Minister, and we are not understood the alarm. Is it like that the council has not acted really on that, and had there been a 4 or 5 years gap, been improved, disciplinary mechanism has improved, or you have done a good job, this would not have been a situation? Is
Yes.
it like that, sir? Yes, Tulchan sir.
Umesh, you pointed out a valid question. When few years back, the Prime Minister came on the CA day to address all the chartered accountants. He has given his clear mandate. We want 100 multinational Indian firm, chartered accountant firm. Our profession has not come forward to bring all those things. and that makes the government unhappy with the performance of our chartered accountant. Again, this requires also one of my points. Why I'm putting now the government view. Number two is, this is one of the points. Number two is other sister concerns like cost accountant as well as the company secretary. They never oppose government move, whereas we chartered accountant oppose every move of the government, whether it's right or wrong. We are not discussing right now that, but we are opposing, and that make the government on the back foot, which Modi government is not as such that they will go on back foot, because they have their clear mandate what they want and what they will get. So the disciplinary mechanism, the changes required in the disciplinary mechanism was a long back issue, which we should have acted upon, but we have not acted upon. But in the name of the disciplinary, the government is bringing something which is not good, because they already have the representation on the board, and whether their government nominee is against us or whether they are recommending the same thing which our institute is recommending, the government should have considered that. And I believe that they are also happy with performance of the Chartered Accountant Act as well as the Chartered Accountant. There are few fishes, the bad fishes in the pond, but that doesn't mean that that everyone is wrong, and the law is
Sir, how to remove
Let,
those
let,
bad fishes, as you said?
yes.
let me
This
let,
is
let me put one more thing. See, any profession is a skill, individual skill. When you say chartered accountant or even a cost accountant, company secretary, or even the function of a doctor, medical profession, or even a advocate, it's an individual skill. Profession itself is an individual skill. It is not a corporatization. Rather, bringing the firms in the disciplinary mechanism one good step, but in the name of development, the objective of development is, apart from the regulation they have been adding the word of development, are they going to go for a corporatization of the practice, CA practice or the profession? How far it is good, how far it is bad? See, globalization is one thing, no doubt, but apart from the globalization, the profession is going from the individual to corporatization of practice. And once you start corporatization, there is a vertical split of audit and non-audit function. And I can foresee in coming years, there will be a complete split. There will be only few organizations will be doing the audits, and most of them, other people will, individual and small firms will not do at all audit because the risk and rewards. Please,
yes.
comment by one from all stalwarts.
Are you
sir.
aware of, are you aware, are you not around to face this risk, or you'll be something like that?
Not at all. It is not a matter of risk. As an individual, when we are signing for the lifetime. For any years, after signing, anyone can take us for the ride. Even a small letter from any person, disciplinary mechanism starts working on that. So that is what ADC is actually. So it is not like that. Even if individual sign or even a firm sign, as of now, the firm was not in the DC within the purview. But individual member is always, even a small certificate given by any chartered accountant has the same implication of signing any audit report of our financial statements. So once it is signed by a chartered accountant, it is ultimate, and he has to be taken risk and responsibility, accountability for the lifetime. So there is
Then
no
why
question, we are not aware.
Then the why is like the scams like DHFL and all. If I want to name it more, so why this
Sir,
kind
any
happen after
scam,
signing the?
Ganesh, let me put it, any scam, it is always a collusion. It is not one man show. ताली एक हाथ से कभी नहीं बजती है.
तो वही
And that
बोलता हूँ
too
कि
the last person.
why CS are go in hand with the corrupted promoters? Why say
It is
गलत है
not,
तो गलत है भाई?
no, it is not going in hand with anyone. Rather, it
Ganesh
is,
ji,
yeah, please.
Umesh ji, I will take your question and
Yeah,
the reply of Ganesh ji.
I'm here for a healthy discussion. There is nothing
Yes,
against
yes,
anyone. Okay,
yes,
it's a healthy
Yes, sir.
discussion.
Sir,
Please.
we are discussing for the betterment of the profession, and that's
Makes
why
sense.
I put all the points which you have
Yeah,
put it.
yeah. you said rightly, sir, because there are very few bad fishes making
Sir,
this pond,
we are
ugly on that.
because the council and our institute office bearer are looking to more control in the council. They have their personal agendas and other things. Because of that, maybe there are reasons that they are unable to act on any form. And again, our Chartered Accountant Act talks about the first schedule or second schedule, which is for the members, not for the firms. The first time the forms has been introduced by this government, by this Amendment Act, that forms will also be get penalized if something goes wrong, and that's the welcome move. We should appreciate the government that they bring that. Now, the second point which you have told, that why chartered accountants are signing. So this is an individual choice, and that's why the experience of the chartered accountant. See, we have one bad thing. Even though we are not in the same expert in that area, we jump in to take a business, or we compete with the other chartered accountant, and that's why this competition has killed us only. Because the chartered accountant knowledge, we are underperforming. Our performance is underperformed. We have a more capacity, more knowledge. The problem which I have told you, that appointment of the chartered accountants, appointment of the chartered accountant is done by the company. How, and in the past also, when someone is put finger on something wrongdoing, our disciplinary committee have taken actions which was not enough.
I agree with you. I agree with you.
To penalize those bad chartered accountants. As I told, there are a few fishes which are very bad in doing, and that one point which I will put, the old council members, they are getting a highly paid or a highly reputed post after removing from the post, which will degrade our profession, because they have their personal agenda, and due to this, our whole chartered accountant fraternity is get a bad name. We chartered accountant.
Ganeshji, can you put your points? What are the good points you feel from the entire bill? Please, Ganesh sir.
No, the bill is like it's putting it more competitiveness. I can say that it's a good. Yeah, it's more competitive.
Any other points?
Other points, yeah, you are already there. I'm just talking on the good points.
We want basically what. See, we are going on a discussion in all 360 degree. Members, non-members, and other stalwarts also should comment on this, what they feel about the entire profession, what needs to be done. See, government has done in one way, introducing the bill, but there are many sides, many issues, and many dimensions. So, what are the dimensions you feel, please?
Actually, I want to add. I want to add. Sorry, I've been late because of some other commitments. All of you, happy Gudi Padwa and good afternoon to you. I want to add this is that this particular bill, the small and medium enterprises always been targeted by those disciplinary committees that you have compromised on signing or you have compromised on certain decision. I think according to me, there are a lot of things that I have seen for the big top organization also, they compromise a lot sometimes. And I think my working as a small medium enterprise is more accurate rather than the big enterprise. They say कि वो ठीक है बाद में देख लेंगे कुछ भी आया तो, and they are the working directors or working partners. So मेरे हिसाब से जो SME segment के जो हमारे जो भाई बंद है जो वो है वो काफी केयर लेते हैं. एक आध दो मछली हमेशा कोई भी पॉन्ड में खराब रहती है तो उसको हमें आई डोंट थिंक सो कि वो उसको हम लेके एक जनरलाइज स्टेटमेंट दे सकते हैं. Which also Nilesh bhai, who is a mentor to me, I am with Kimchi Conversion Company in our past. We were doing our best. कोई आदमी 100% हमेशा सही हो ही नहीं सकता है. 90% हो सकता है, तो भी वो 10% के लिए अपना एक डिस्क्लेमर डाल देता है कि भाई ये डिस्क्लेमर है, मैंने डिस्क्लेमर ऑलरेडी इसमें ऐड किया हुआ है. सो आई डोंट थिंक सो कि outsiders should represent our institute for any disciplinary kind of thing, because वो हमारी नीटी ग्रिटी को इंटरनली नहीं समझता है. मैं ऐसा समझता हूँ कि ये जो गवर्नमेंट का मूव है टू इंट्रोड्यूस पीपल फ्रॉम द आउटसाइड fraternity or outside professional come and do disciplinary action for our members, I think it is not justified. I signed a petition and I told them also it is not correct.
Sir, this is a very valid point that you raised. A non-chartered accountant is heading the body, and that too specifically a bureaucrat on a disciplinary board or disciplinary committee, or even the coordination committee. As far as the coordination committee is there for 3 institutes, that is the point for the healthy discussion and healthy coordination. But as far as DCs are concerned, or the disciplinary committee or the board of discipline is concerned, a committee headed by and the majority headed by non-members, it's not really something which we feel that it is taking away, snatching away our control or our rights to regulate our profession. Sir, Barve sir, you have been a council member. What you feel on this point?
No, there should be a petition filed to the council, to the ministry in a proper manner with all the documentation by the central council. Barve sir is a very senior person, so if at all somebody from our SME foundation can actually write a particular letter to central council or a president, it has to be strongly condemned that yeah, you can have some representative, but you cannot have a full disciplinary committee who is represented by outside people like a bureaucrats or any other profession.
Agree with Rajesh bhai, very well.
Point is very valid. Like right now, out of the 5, 2 are government nominee and 3 are the from the council. So if this is a combination, government want 3 from the government side and 2 from the council side, and the person who are not coming as in a disciplinary committee, they are not having knowledge of chartered accountant, what chartered accountant is doing and what they are not. So that is wrong, and we should oppose the government move which they are saying. If they have any problem, other two members, government nominee, if they have any issue, they should point it out in the committee meeting. That they are
how they come to know? They don't know the laws. They don't know any the chartered accountant law. I think if they are also outsider, they should be, I think, from the industry of a chartered accountancy where they are not the COP holders. See, if they are not COP holders, say Uday Kotak is on the board, I'll be happy to introduce to my disciplinary committee. Because Uday Kotak chartered accountant भी है और वो industry से भी belong करता है. उसको नीटी ग्रिटी ज्यादा क्योंकि वो अदर साइड ऑफ टेबल पे बैठता है जब भी उसकी बैलेंस शीट साइन होती है कोटक की.
Yes sir. So same way,
if there's kind of people, but आप बोल दोगे कि ये MLA है, ये member of parliament बैठेगा, तो I think Piyush Goyal जी बैठे, I'll be more happy because he's a chartered accountant.
Yes.
He understands. सुरेश प्रभु जी बैठे, I understand. But वो कोई जो अभी वो particularly जिसको knowledge ही नहीं है, maybe qualified है, नहीं qualified है, वो ब्यूरोक्रेसी करेगा, यहाँ आके तो और खतरनाक हो जाएगा.
This bill is a tip of iceberg itself. It's a beginning of rather the cutting the size of a ICI from senior body, second one in the world, to I think the grade 2, grade 3.
Yes, Unmesh ji, Rajesh ji ने बहुत valid point कहा है, and our own professional brother will only understand our difficulties and our
yeah.
So I think that proper representation has to go by the various kind of, जैसे BFSI अपना एक यूनिट है, तो मनोज जी इसमें अगर वो पिटीशन फाइल करने के लिए एक मूव करते हैं, तो we around 200-300 people from Bombay can sign a petition and hand it over to the president कि भाई हमने ये साइन किया हुआ है, आप प्लीज ये पर्टिकुलर मूव को इस तरह से वो करिए, रिप्रेजेंट करिए. इससे क्या होगा कि प्रेसिडेंट जो डायरेक्टली वहां मेहनत कर रहा है उसको थोड़ा स्ट्रेंथन मिलेगा कि बहुत सारे चार्टर्ड अकाउंटेंट्स है जिन्होंने ये मेहनत की हुई है, बिकॉज आई थिंक बिग फोर को ये कोई फर्क पड़ने वाला नहीं है ये होता है या नहीं होता है, बट एसएमई एमएसएमई को बहुत फर्क पड़ने वाला है इससे, बिकॉज जरा सा थोड़ा सा ऊपर नीचे हो गया तो कोई आदमी 100% एसएमई को 10% कॉम्प्रोमाइज करके ही साइन करना पड़ता है, वो अपना डिस्क्लेमर डाल देता है, फिर भी उसके ऊपर डिसिप्लिनरी कमेटी अगर कोई एक्शन ले लेती है तो उसके लिए उसकी दाल रोटी का सवाल हो जाएगा. So I don't think so वी शुड from SME and MSME kind of firms we must do and help them out, because एक दो मछली इधर उधर खराब हो सकती है, बाकी सब मछली कोई खराब नहीं है अपने स्मॉल मीडियम प्रैक्टिशनर में.
Sir,
सब
मेरा
बहुत
point
मेहनत
ये
करते हैं और
था,
डरते भी है
why
साइन
the
करने से.
council has not taken the help of the past president to form an advisory group to take this discussion and make the complete suggestion
So
representation.
we recommend Manoj ji, we will recommend.
Yes, because this is where need
Manoj
of
ji, Barve
our,
ji, आप recommend करिए please.
yes, because the past presidents are there who have seen the glory of the
Absolutely.
profession. They have
Very
seen the
valid
glory
point.
of the
Very valid
profession.
point. 100% करना चाहिए ये.
Umesh ji,
Yeah, please, sir.
see, basically over the last many years, the credibility of the profession has been built up by the MSME and SME firms.
Yes,
So
sir.
in the public perception, what is the perception about CAs that has been built up by entire SME sector for last many years. Now, after looking to what has happened over last many years, what has happened at NFRA, what has happened at PM expressing perception, what is happened, what is the perception expressed by finance minister. Now the issue is who is initiating the actions if on introspection we find that something is not correct or something is objectionable. Now issue is whether any actions have been initiated in the past by anybody and what are those actions, and now the important question is who will initiate the actions. So first we have to decide on introspection what appears to be not so correct, and if that is the impression, then what exact actions are going to be initiated, by whom, when, and to whom those issues will be addressed in the government sector or to the stakeholders. I think that action plan, commitment to that action plan is very much important. It has to be defined what is the action plan, who is taking action, what action, when it is going to be taken, to whom the representation would be made. All this comes under the action plan, and I think that has to be crystallized immediately.
Yes, sir. You rightly pointed out that there should be some actions, there should be time-bound programs to take the disciplinary mechanism go ahead. I do agree, but heading by some non-chartered accountant, what is your view as a council member, ex-council member? What is your view? Is heading by bureaucrats or maybe somebody else, non-chartered accountant? Do you agree with this point?
See, basically, if you look to the many other sectors, look to the tribunal, there would be a law member who would take help of technical member, but decision probably would be of the person who is expert in law. So I think the important aspect would be whether the technical opinion is being taken or not. If the technical opinion is being taken from two members, then it's fine. If the technical opinion is not taken at all, then that is an issue. But in any field, even at the High Court, you take your case to the High Court. Is it when the cases relating to CAs are going to High Courts, who is going to decide the matter? If the judge wants some help on technical matters, he can always appoint somebody professional to help him, or he would take technical help. So I think per se it is nothing wrong that some non-CA would be deciding the case. Question is to what extent he gives importance to the technical aspects of the case concerned, because now the perception of the government is self-regulation has not worked. So therefore they want to have a control saying that, okay, on certain issue, the technical persons will explain to the presiding officer that, okay, technically this is right, this may be appropriate, this may not be correct to that extent. But the decision on a wider scale, on the major, what the government wants is in the interest, the decision in the interest of public, decision in the interest of investors. Now, such decisions would be taken at a higher level by some other persons. So per se, I don't find that as a very
Sir,
So
medical
previously
council is
also
not
last
allowing.
72
Sir, medical
years,
council is not allowing. Bar council of advocates are not allowing.
no,
You
but
understand?
non-members were there on the discipline. Two government nominees are always there. Why they are? See, their opinion has always been considered, and even we also heard from the
They should
many
not be
council
part in the
members
vote.
ki
They should not be
unless
part in
and
the vote.
until the government nominees have been taken into consideration, no decision have been passed, no decision has been taken by council. So they have always been given a preference. So in spite of that, so is it a failure of our council or the government nominees who are on DC?
They should not be allowed to vote. They should be only briefed about what are the matters are. If they try to vote, then they will try to rule the
Hijack.
council also. According to me,
Yes.
if at all we want to be in the part of that.
See, the perception of the government has been that the decisions or the punishments offered so far in many cases are not to the expected level which the government wanted. And I think that is a step therefore in that direction, that on the broader scale, the decision should be of a non-member or who might
Sir,
be a
here I would like to just add one point. See the major frauds which have been happened over last 20 years, what we can say. Do you find there is any small, medium practitioner SMPs are involved into it? Is it not the large, big firms?
Absolutely.
So in that situation, if they are not been given proper punishment, is it the failure of a small, medium practitioner auditor, individual auditors?
No,
Why they
no,
have
no.
been targeted? Why they have been regulated by any non-chartered accountants? Apart from that, ultimately what council you find out of the for 32 council members who have been elected representative, hardly 3 or 4 maybe from the SMPs. Rest of them are either directly or indirectly backed by the big 4 companies. Unless and otherwise they will not get the vote or they will not get chance to get elected. So is it a hand in hand? And that has been getting affected to the real practitioners, individual practitioners.
Absolutely.
Unmeshji, think a different situation.
Well, sir, just to interrupt, I am just have to leave because my battery is just 1%. So
Yeah,
thank you,
yeah.
and I'll be there for everyone for any
Thank you,
any
sir.
of the
Thank
kind
you.
of help
Thank
that
you,
we
sir.
need.
Thank you, Rajesh ji.
Thank you.
Yes, yes.
Thank you.
We will need because your firm has a two past presidents with you. So we'll need their help
No,
in this.
definitely, sir.
See,
Thank you.
Thank
Rajesh
you,
ji,
sir. Thank you.
Rajesh ji, only 1 minute. See,
Yes, yes.
more than 90 to 95% of the listed companies are being audited by major big firms and
Correct.
not by small firms. Now, their
Correct.
cases of banks and such companies, they are going to NFRA. Now, if NFRA is going to decide the case, whose majority is there on the disciplinary matters of NFRA? Are they chartered accountants in majority to decide the case? So as it is, I am saying, what did we do when NEFRA came? NEFRA disciplinary matters already where all listed companies, banks, insurance companies are going, public interest entities are going. There is no majority of chartered accountants. And what did we do then? If we are not doing anything at that point of time, then this is only for the other SME people, where the cases are going to come to these disciplinary authorities. The real crux is going to NFRA. And there, what is the position? So I think when we talk about this matter, also look in the broader perspective, where the major cases are going, if at all, and they are going to NFRA, and there, who is deciding the case? All the members decided or appointed by the government.
But I
Now,
think what I want to only add is that we should raise a voice. हम जीते नहीं जीते वो अलग बात है, but अगर voice raise नहीं किया तो then it will not be hold good. That's only.
yes.
Thank you, sir.
Yes.
Thank you.
Yes, sir. So things are moving in a very different way. The reform, now the word reform is more important over a period of time. There are many groups who are working for reforms. Yes, we need a reform in ICA, but this reform is something different also. Whether there is a good thing at the end of the tunnel, good light is there at the end of the tunnel or not, that years to come, the impact will be there. And the result may be in a years or 4 years or 5 years down the line, we can see what has actually going to happen because of these changes. But yes, change is always going to be there. The things are going to move in a different way. The economies are getting opened up. The new firms are coming. There are so many things are happening. Are the C chartered accounts are really geared up to accept those challenges? The SMPs, yes. Are we there? Even there is one good thing. Yes, CAG panel firm is not going to audit the books of accounts of the ICAI. Yes. Now this is where the point is, why we are not opened up ourselves. If you see the parliamentary debate about CA profession itself is open debate, it is openly live telecast. Why the council meetings are not been telecast live or not been open? Why the minutes are not shared? Let the member, the real stakeholder of the ICA profession should come to know what exactly is happening in the council. What is wrong to that? Why we are not aware about the so many things that this bill may be aware by the ICAI for the discussion maybe 2 months before, 3 months before. Why it is not been brought to the notice of the members for the open general discussion? By the time before it comes to the parliament, there many suggestions would have been there from the individual members also. I think we need to understand this perspective. Now it's an open economy. Then the transparency word has a buzzword. Now the transparency should be everywhere. It may be a branch meeting, it may be a council meeting, it may be a regional or it may be central council meeting. Let the thing should happen openly, how the things are happening, what council is thinking about this entire bill or about the profession. It has to come to the members. Sir, what do you feel about this thing? Barve sir, please, being a council, ex-council, why it is not the open discussion? Council meeting is live.
See,
At least for the members who can log in.
What on the I have been always saying that these transparency and good governance, these are the matters which have to be enforced strictly and immediately, and those things certainly have influenced the thoughts of the other stakeholders, obviously, and of the members also. So that is exactly an issue. Last 15-20 years, even the recent cases, are we transparent? Let us do introspection. The things, whatever things have happened, have they been right? If they have not been right, whether the actions have been initiated and whether the actions have been taken or not by anybody. Now, in that context, this I think the present bill also comes in line with what is happening over last many years. And important thing is, if we find on introspection that yes, something appears to be not right, then we must hold somebody accountable as to who would take up our issues with the stakeholders, with the government. Because it's difficult for individual members to take up the issues with the government, except the member can write to the Prime Minister portal, or he can write to MCA, or he can write to Ministry of Finance. But ultimately, the elected body, the association, has to make the appropriate efforts and take up the issues faced by the members and the profession with the appropriate authorities. And if necessary, I don't see any reason why the elected bodies or the associations should not refer the matters to judiciary if in case they are so serious as to affect the interest of the profession and the interest of the professionals. I strongly feel that the elected body has to take care of the interest of the profession and the interest of professionals by even resorting to judicial means if it is found appropriate.
But who is
Makes
going
sense.
to that? It is who is there to go against the government in the court. I have never seen any action by any council, or maybe last 72 years, that they are going against the government in the court. Even
But
for the matter of extension, last couple of years, we see that council say you should not say like this, you should not say like this. What is the wrong in taking the government in the court? Is it we are doing something wrong? No, it is a fair third party discussion and decision about the things, sir.
so that is exactly what members have to ask the elected body about the necessity of taking certain actions, taking actions at appropriate time with appropriate authorities, including judiciary. And if they are not taking,
Yes.
the members should ask them. Members at large, if they ask, then only there would be some way of finding a solution.
Sir, one more point that I would like to bring to the notice of the other members also. See, the term is now getting 4 years. There may be some technical discussion, the point may be there in the bill. It is more or less 4 years, two terms. Now, sir, if you see the government, the MPs, MLAs, they can be 7 years, seven terms, 8 terms, rather they have been seen pride. कि भाई सात बार मैं जीत के आया हूँ, MP बन के आया हूँ, MLA बन के आया हूँ. Why it is 2 terms? Let the members decide. Let the member decide how many times this council member should be there as a council member. Why any decision of terms? What is the pros and cons? Is it not a dual standard? There is the act itself says that it's a 3 terms earlier. Now it is being reduced to 2 terms. But why it is in a democracy in this situation? Let the member decide कि जो अच्छा काम कर रहा है उसको 5 साल नहीं 15 साल रहने दो, 20 साल रहने दो. जो नहीं अच्छा करता होगा उसको 1 साल के बाद तो 1 टर्म के बाद निकाल ही देंगे, वो लोग ही वोटिंग नहीं करेंगे. So what is the thought process behind reducing from 3 to 4 years, reducing the terms from 3 terms to 2 terms and making it 4 years? What ideology is there? What is the objective?
See, can you check up how the elections are being fought? And if we find that in democratic way of holding elections, you may find MPs getting elected 5 times, 6 times terms. Now, the members who have won the elections, say consecutively for 4 years or 5 years, can we say that their all policies or their actions have been good? See, there have been various disadvantages of the democratic way of elections. And there are concepts, as I said, basic concepts of conflict of interest and the formation of strong groups. Formation of strong groups may be in terms of financial hold, or there may be political hold, or there might be many other considerations which may not be appropriate. But in the democratically fought elections, it's very difficult to say that you would get the type of leaders who would academically take the steps which the professional may find appropriate. The decisions taken by the democratically elected members would be maybe different than what the decisions are found appropriate by the academicians or by the professional experts. I think there is a basic conflict of interest involved in such democratically fought elections, and therefore I personally think there has to be a limit on how many terms a person can serve on the important committees like council.
Yes, sir. Sir, the point, one more thing what we see apart from this, is it that government is having eye on the corpus of ICAI? Tulsian sir, I would like to have your views also on this point. See, when we talked about the corpus, they said it is a corpus built by the institute, but the power given by ICAI Act itself. We are not denying. Rather, any organization, anything, it is under the Act itself. So we are functioning under the Act, but it is a corpus of our own members, students, generated by them, hard-earned money that has been put by the members and students, and out of that, whatever may be the cost, whatever that we are paying, out of that the fund has been raised. So what is the point of they saying that it is our own money, it is a public money, where we are denying? But yes, the control and regulation of that money is always should be the prerogative of the ICI members. Why the other outsider stakeholders who are not, rather what we see the functioning of the government itself, what their funds give to these corporations, bigger corporations, and what is happening with that fund? It is lost, getting piped in a drainage, rather we can say crores of monies are getting wasted. Because
See,
of the, rather even just take a simple point today, this would have been a question to FM in the open debate itself. What had happened from the 1st July after this to 2021? The income tax portal has been introduced, and what hell loss of professional time, money, energy has been there because of some wrong decision. Had you want to implement such a decision, it should be parallelly run, and it is a universally decided policy that as far as any new software has been introduced, it should be parallel run for some months. When the things are happening good, then it should be brought to the live stage. So this decision has made a huge loss to the profession. Who is going to be accountable? And they are asking us to be accountable for any wrong which is not done by our member. Yes, sir.
see,
Shashikant, sir.
Umeshji, your point is valid. The thing is, I will quote one story that any illegal money or legal money which you have, the institute has got it from a student or member by contribution, by increasing the fees, by increasing the examination fees and others. They are not able to spend that on the welfare of the chartered accountants. This is one of the point which I would tell you, that a government have an eye on the ICI fund which is lying idle for so many years. I thank our past presidents who have started contributing to increase the infrastructure for the benefit of the member, but still that is not enough. I found that in during the COVID period, institute has not come out with any help to the chartered accountant families or the marginalized or proprietorship firms who are struggling to get the funds. As we are a noble profession, we are not saying that institute should fund the chartered accountants, but they certainly could have done the downsizing of the fees. Still, the fees are high. Although we always compare with the other institutes, other institutions, and government by bringing IIA is also want to milk that area which is right now milking by the coaching institutes. Coaching institutes are in all the street and corner who are helping the students to get the knowledge of what chartered accountancy is all about. Along with because of our uniqueness in the profession, our practical training given to the students, we are still ahead of any other institutes. And that's why I told you, even in IIA, which the government is proposing backdoor entry for the competition in the name of the competition before the ICAI, we should strengthen our students, as well as we should increase the knowledge of our members. Just giving a CPE hours is not enough. They have to work seriously to increase the knowledge and testing the knowledge of the members who are doing the audits and others. And they could have spent a lot of money to innovate, which we have failed. We have failed for bringing the top 100 MNCs, Indian MNCs. And that is the reason the government is against the chartered accountant. But at the same time, as a chartered accountant, we can say all the 350,000 chartered accountants, or you can say 125,000, 150,000 chartered accountants in practice, most of them are proprietorship or individual firm. We have around 25,000 firms, and rest are the proprietorship firms or individual members who are practicing, and the individual members are working very hard to get survival in this competitive market. As well as when we say the survival of the competitive market, our expertise has never been questioned by anyone. Even the government knows the impact of the chartered accountant. They're working and they have told them partner in national building. We are here to build the nation, and that's why we never oppose government's move, but we are very lagging behind as compared to the technology upgradation or knowledge upgradation of our members and our students. So there they should have spent and use of the money which government is eyeing on. Government
just to make you aware about the facts, I have made 2 representations to the ICA president in June 2020. About one is the fee waiver. Then there are so many other issues. Apart from that, there should be some sort of beneficial things for the members, distributing some funds to the members for the time being, not as an entirely non-refundable, but as a refundable basis for the time being. None of these been taken up by that council, and I have talked to many council members also, but I have been updated by them. We cannot do such thing because this money is not belongs to us. We cannot spend for these purposes. In spite of that, we are spending. Council has given 21 crores rupees to PM Care. What whether that is within the purview of the council, whether it is yes or no. It is a good thing. It is a good thing for the donating to PM Care. But why the same money of a member or student is
cannot be given to the members? Correct. That's the point. And that's why I am saying the failure is not of the government. Failure is of our councils or the regional councils, central council, who have not acted upon, even though lot of indications has been given by the government on time and again. So we are not taking something on our head. See, we are not saying that this law is in a good taste. Law is bad in taste. But whether we are united, we are not united enough. We 27 and 28, when the Lok Sabha has passed this bill, at that time also on 31st, if all the chartered accountants all over the India have made the government realize and ask for ask for their revert back, and we could have stopped even for one day of 31st, I could have tell you that the scenario was changed. But this is not the case, because there are few councils or members or past members who are still believing that IIA is good, or the government whatever is doing is good. I'm not saying that commenting on any members is good, but at the same time we should look at our action. Our action is not louder enough. Our action is not louder enough to make the government go on back foot. This is my point, and we should we should oppose the government move, because our numbers are 3,50,000, but don't go at 3,50,000. We can convince even 10 industrialists or 10 clients. So the numbers will be very huge if we want to oppose it. But where our brothers and CA professionals, we are not opposing in a creative way or in a positive way. We are saying this is bad, this is bad, this should not happen, this should not happen. This is a Modi government who listen to only when you go with some credible numbers as well as with some credible information. In last 72 years, we have performed very well, and that should go to the government, that due to the chartered accountant, you are able to increase the GST to 1,42,000. If we don't help, then where you will be? We chartered accountants is a partner in national building. We always help government by whatever way. The government have spent a lot of money on the income tax website. Government has spent lot of money to bring out the tax audit standards and other standards and this standard, that standards. But whether they are giving some results, because our chartered accountants, they always believe whatever we say, they need some bali ka bakra ki jisko wo tang sake. But the problem, real problem, they are never talked upon.
Yes,
That
yes.
why account goes NPA? Why
Sir,
account goes NPA?
a last question for the day. One point is that just now the bank audits have been allotted, and I've seen only 18,000 plus firms have been getting the audits as far as statutory branch audits are concerned, whereas we have more than at least 70 to 80,000 firms, small medium firms. So where is the fair allotment? Who is the role to play? Is it
So that's why I'm saying the council.
when the IIA is going to be introduced over a period of time, as the state select committee, standing committee is suggesting, once these licensed auditors are going to come, what is going to be in the hands of the SMP, small medium practitioners? Is it not even today also the tax consultants who are not chartered accountants are snatching away the bread and butter of the members? In the name of fintech companies are taking away the taxation work. Non-chartered accounts are period of time. Once the IIA been getting introduced, the licensed chartered account, the auditors are going to come to do the audits. What could be the future of a chartered accountant? Is it really going to be a tough time for new entrants, new members, and even the old members? Yes, I want a view from all the participants, even including Barve sir also. Please, sir. And then we'll have to take a day in for the day, because today being a Gudi Padwa day celebrations, maybe. So we'll have to be with our family also afterwards. Please, sir. Thank you.
See, we have to see how the exclusive areas for chartered accountants, how they have grown over the period. Now, if we see that audit was only the exclusive area which was meant for chartered accountants, now it has been diluted to a great extent. And we find that the talks are going on advising the chartered accountants that they should practice in insolvency and arbitration and forensic and all these areas. But these areas are not exclusive to chartered accountants. So the students or definitely the persons who would like to come to this profession would consider as to what is the special advantage of becoming a chartered accountant, because the same objective of, say, they want to practice in insolvency, they can pass the examination there and undertake that work, or they can pass LLB, become lawyer, and then they can appear in various types of areas. So in the long run, the exclusive areas for chartered accountants need be enhanced. Now, that is exactly the vision and the long-term steps which have to be considered by the body or by the association as to how do we enhance the areas of work which will be exclusive to the profession. Now, I think that is going to matter a lot in future.
Sir, just to one point to add, if you see the ease of governance, ease of doing, government is reducing the audits itself, because they are increasing the threshold limits from 1 crore to 5 crores to 10 crores, and it may be coming, the bank audits may go, now almost 80% of bank audits have gone, and even the corporate audits also, if you see, the limits are changed drastically, so small companies may not be audited at all. So things are moving in such a direction that the audit itself are getting reduced in numbers, and then exclusivity in that area, then it will be competition with our own member itself, and that too with a big firm, small firm. How to survive? That's the question.
I'm saying there have to be new areas which would have to be thought over and taken up with the respective authorities so that they will be marked as exclusive areas for CAs. Supposing, just consider that in case if it is made obligatory that any bank advance, if it is more than say 100 crores of rupees, the proposal has to be reviewed by a qualified chartered accountant and only by a chartered accountant. Then would it not add to a major business for the profession, and which would be an exclusive business for the profession? So I think radically the thought process and the vision would have to be different. Otherwise, the new entrants may look to other opportunities directly going to the respective areas, like they can go to institution of valuers, they can go to institutions for that insolvency, and they need not pass chartered accountancy examination at all for the your artificial intelligence and all those areas. People can directly go to software
Sir,
area.
but the thought process of the government is absolutely opposite. If you see the GST audit, they said no, it is the cost accountant also introduced. We are not talking about any institution. It is the approach of the government. If you see, they are always thinking in a different autonomy. They want to dilute your autonomy. They want to monopoly is to be reduced. So always the intention of the government is on a different side. They are not interested to concentrate the powers in one hand. So they are diluting. So how they can take the call of any such area where they want exclusive auditor or chartered accountant to be played a role, a major role. I think this is a very far-sighted thought process, but it may not be achieved in long run. Because and then advocating that type of business with the government by our council is again a big challenge. Because even retaining our own existing business, exclusive business is a question in question. I think getting new business for a chartered accountant will be a very difficult scenario. That is what I feel. Sir, please.
In that case, yes, there would be heavy competition from other institutions which would come up, and certainly depending on the scale at which they operate, it is going to affect the intake to the CA course by ICAI. Certainly, if there are 20 institutions get formed in different parts of the country, and if they start their courses not exactly like IIM, but each one of them starts training even 10,000 students, 10,000 students multiplied by say 20 institutions would mean 2 lakhs of students. So I think certainly it will affect the future intake. Depending on the cost and the quality obviously given by the other institutions. But yes, this will affect in future the intake for the students. About the quality of audit, I think it's an entirely different aspect. And
sir, one point I would like to make, it is not a praising of itself, but see the Supreme Court recently in certain remarks has been made. The ICA, I think the Supreme Court or Bombay High Court, I don't know exactly, but court's remarks are there. The examination standard of ICA is something different. Even law should maintain such type of standards. That is the remark, positive remark as far as our standards are concerned from the judiciary. Whereas the government is thinking कि भाई इतने सालों में बस 3 लाख CA ही हो गए, 70 साल में क्यों ज्यादा बढ़े नहीं? They want numbers, they want merits, they want quality. What is the intent? What is the intent? Basically, I really fail to understand what is the logic behind the increasing the numbers. Why the number is important? Quality is important or number important? One side you are saying that the quality is not up to the mark, the audits are not up to the mark, and once you are saying number of increase होने से quality अच्छा हो जाएगा. I think this is something whether the government itself has two thoughts in mind in process, or they are taking the actions, but the behind objectives are something different.
So who would take the steps initiating the actions? Who is supposed to take the actions? Think over it. Can hundreds of members only take up such issues, or there has to be some association, some body who will have to take up all these subjects and
sir,
issues?
why we elect our council members? Only for that purpose only, sir. This is not just to organize the programs.
So So the answer is clear. So the
Yes.
members, fraternity of members, should request the elected body to take the appropriate actions.
Yes, sir.
Sir,
Yes, yes,
I will tell you, they are not going to take any action, and the government will bring this act in light. It will show as a law of light in coming days, because we are not we are not
United.
strengthen ourselves or united ourselves. Until
Yes.
unless we unite, we are bound to be destroyed by outsiders. In this case,
Thank you,
the
Shashikant
government.
sir. Thank you very much for your comment. Barve sir, thank you very much. This Gudi Padwa we have celebrated in a different way with the open debate, open panel discussion, and it's a very healthy discussion, 360-degree discussion on the very hot
Thank
topic of
you.
CSICA amendment bill. I heartily thanks to all the participants, including non-members, members, Ganesh sir, and so many Manish sir, so many who contributed
sir.
directly, indirectly to the activity. And Manojji, thank you very much for the entire discussion taking on this place. This is because of your initiative of bringing this subject for the today's agenda. And I really appreciate everyone has given a full-hearted, wholehearted discussion about this thing. Barve sir, your initial remarks on a detailed discussion about
Thank you, Urmeshji.
Yes, and all other panelists, Vora sir and Tulsian sir and all others. I really appreciate your open-hearted discussion on this point. Let us take it very positively. जो होता है अच्छे के लिए होता है.
Even though I was a devil's advocate, thank you for the update. Yeah.
Sir, it is. We always welcome. We are always positive, sir. जो होता है अच्छे के लिए होता है.
गणेश सर, आप चार्टर्ड अकाउंटेंट है ना? गणेश सर, are you a chartered accountant?
नहीं.
सर, इसीलिए हमको इतना गाली, आपने बहुत गाली दिया सर.
Welcome guest for us. You are always a welcome guest for us.
सर, जितना मोदी ने गाली दिया था ना सब 2017 में, उतना ही गाली आज आपने दिया. सर, नहीं, ऐसे ही जोक मारता हूँ, बट एक चीज बोलता हूँ सर, डॉक्टर लोग कितने लोचा मारते हैं, कितने पेशेंट को मार दिया इंडिया में. इतना सीए ने इतने लोगों को नहीं मारा है सर. कितनी बिल्डिंग गिर गई, कितने ब्रिजेस गिर गए, कितने रोड पे खड्डे हो गए. उतना नुकसान सीए ने नहीं किया है सर. मैं आपको ये बोलना चाहता था तभी भी. सर, सीए बनना बहुत बड़ी चीज है, आपको शायद मालूम. मैं ये नहीं,
सर, मारने वाले से बचाने वाला ज्यादा इंपॉर्टेंट है, इसीलिए हम लोग यहाँ पे है, जिंदा है.
सर, और मैं आपको बोलता हूँ वन मोर थिंग, फॉरगेट अबाउट इंडिया. इज देयर एनी कंट्री जहाँ पे कोई भी फ्रॉड नहीं हुआ हो? ऐसी एक भी कंट्री मुझे दिखाइए सर. अमेरिका दिखाइए, यूके दिखाइए, जर्मनी दिखाइए, फ्रांस दिखाइए. बर्वे सर
नहीं है.
हाँ,
जहाँ पैसा रहेगा वहाँ फ्रॉड तो होगा ही.
करेक्ट, वो मैं गणेश सर को बोलना चाहता था. बर्वे सर विल अग्री विथ मी. करेक्ट सर, आप सबसे सीनियर है हमारे में.
सर, जहाँ मनी है वहाँ मधुमक्खी होगा.
Given the nature, given the human nature, and looking to the democratic way of functioning our elections, it's very, very difficult to avoid the conflict of interest or the lead or the force taken by the strong players, and therefore it's necessary to have to avoid the monopolies and create different segments.
रूट कॉज एनालिसिस में जाते हैं तो हमारी इलेक्शन जो हो रही है वो कास्ट, रिलीजन बेस्ड या इसी बेसिस पे हो रहे हैं, ना कि मेरिट पे हो रही है. दिस इज वेयर द क्रक्स ऑफ एवरीथिंग. इफ यू इलेक्ट गुड लीडर्स, you will get a good outcome of the things. I think we failed in electing good people who can strongly come up against the government, any wrong moves, or to take them to the judiciary. And if that has been failed, it is not their failure, rather it is a failure of our own, that we are not able to elect the good people who can strongly come up and put our voice to the council or to the government. I think we have to introspect again after 75 years. अमृत महोत्सव आने वाला है, हमारे इंस्टीट्यूट का भी इंडिया का चल ही रहा है, उसके साथ हमारा अगला महोत्सव आ जाएगा. पता नहीं हम उस वक्त सीए कहलाएंगे या सीपीए कहलाएंगे या और कुछ डिग्री हमारे नाम पे आगे हो जाएगी. We maybe, I don't know, change because of the intention of the government is totally different.
Sir,
we have to change the heat.
Sir, CPA may be better, because sometimes I heard CA has been wrongly used, like like a commission agent करके बताता है. So that's the wrong thing.
Anyway, everyone happy weekend.
No.
Have a-
It's in a good, just a healthy discussion. Thank you.
या डेफिनेटली गणेश सर, ऐसा ये सब तो बोलते हैं, कुछ यहाँ से कोई लेके थोड़ी जाता है वो सब मन में.
बराबर.
These are all healthy discussion. तो वापस नेक्स्ट सैटरडे मिलेंगे और वापस ऐसा ही कोई डिस्कशन होगा. Not to worry about this.
Fantastic.
Yeah,
Thank you.
there could be part 2 because the council meeting will be there on the 5th and 6th. तो उसका आउटकम कुछ आएगा तो हमको वापस एक बार मिलना नेक्स्ट सैटरडे या तो उसके आगे मिलना पड़ेगा, इसके लिए डिस्कशन कीजिए.
Sure.
Thank you very much, sir. Thanks for
thank
your
you everyone.
time.
Nice weekend.
Thank you, sir.
Thank you.
Thank you.
Happy Good Padwa.